On January 7th of 2025, two minor children, ages 17 and 15, reported to the Pleasantville Police Department. They advised police of where they lived and it identified this defendant as their father. The children walked to the police station to report that their parents had not fed them, and there was no electricity, gas, or running water in the residence. They said they would only eat on Sundays and Wednesdays when supplied food from the church.
Yep. Okay. Go!
Will you hand me my screen box?
Now go.
-121-0102. The hearing today is to consider the prosecutor's motion for pretrial detention. The matter is being conducted virtually. I'll take the appearances of counsel, please.
Good morning, Your Honor. Nicole Campbell on behalf of the state.
May it please the court, Greg Imperial Law, on behalf of David Doyon.
Counsel Imperial, can we mark this as your client's first appearance today?
We may.
And have you had an opportunity to just tell your client and advise him of his rights at this hearing, including his appellate rights?
Yes, I explained to him that what a detention hearing is.
The court is satisfied that the defendant has been advised of his rights, including his appellate rights. Additionally, I've had the opportunity to review the following in this case: complaint warrant, preliminary law enforcement incident report, an affidavit of probable cause, and a public safety assessment with a PSA run date of the 11th of January 2025 and a run time of 9:45 a.m. Prosecutor, are there any further exhibits that the state intends to rely upon for today's hearing?
Nothing else from the state, Judge. Thank you.
Defense counsel, any objection to marking the aforementioned exhibits?
No, Judge.
I'll mark the complaint warrant packet, affidavit of probable cause, and preliminary law enforcement incident report collectively as S1. I'll mark the public safety assessment with the PSA run date of the 11th of January 2025 and run time of 9:45 a.m. as S2. Defense counsel, are there any exhibits that the defense intends to rely upon today?
No, Judge.
And defense counsel Imperial, does your client intend to challenge probable cause today?
We do not.
Even though it appears to be a stipulation as to probable cause, prosecutor, if you could please briefly set out the facts and circumstances that you wish the court to consider when considering probable cause.
Thank you, Judge. This defendant is charged on this complaint warrant with two counts of second-degree endangering the welfare of a child, relying on the affidavit of probable cause that was marked as S1. In summary, on January 7th of 2025, two minor children, ages 17 and 15, reported to the Pleasantville Police Department. They advised police of where they lived and it identified this defendant as their father. The children walked to the police station to report that their parents had not fed them, and there was no electricity, gas, or running water in the residence. They said they would only eat on Sundays and Wednesdays when supplied food from the church. A search warrant was executed on the home, which did confirm that the home was in disarray. There was human feces throughout the entire upstairs bathroom. There was no heat or electric in the house. The children appeared to share one bed using the same blanket. And there did appear to be a small fire and a bucket to try to provide warmth in the house. So based on the affidavit of probable cause, I would ask that you do find probable cause for these two charges. Thank you.
Probable cause is a relatively low standard. Probable cause is a well-grounded suspicion that a crime has been committed and that the defendant has committed the crime. Based upon the representations made by both the defense and the state, and I'll note that the defense stipulated as to probable cause, the court finds that on the 7th of January 2025, the two minor children who are the alleged victims in this matter, their initials are DD and HD, went to the police department in Pleasantville, New Jersey, to report that they had been residing with their parents, one of them being this defendant. They reported that they had not been fed and would only eat sparingly twice a week. And the children also advised that they were afraid to return to their home with their parents. They were examined by medical professionals who determined that the children were malnourished. There were also reports by the children of drug use by the defendant. After a search warrant was conducted of that residence in Pleasantville on the 8th of January 2025, that investigation documented deplorable conditions in the home, including severe habitation and hygiene issues, including human feces throughout the bathroom. The home was in extreme disarray. There was a lack of heat or any electricity in the home. And again, severe habitation-related issues regarding living conditions in the home. Again, having reviewed the preliminary law enforcement report and affidavit of probable cause attached to the complaint warrant, along with the stipulation by the defense, the court finds and concludes that the state has established probable cause that this defendant is an eligible defendant, and he committed the charged offenses of first, a second degree NJSA 2C:24-4A2 endangering, abuse, or neglect of a child by a caretaker. And again, another count, second degree NJSA 2C:24-4A subpart 2 endangering, abuse, or neglect of a child by a caretaker. For the reasons stated on the record, probable cause is found for those charges to issue. Moving back to S2, which is the PSA that was previously marked, the court will note that the PSA has a score of 3 for failure to appear and a 4 for new criminal activity. The recommendation of the PSA is to release with conditions. It recommends bi-monthly reporting. It has no new violent criminal activity flagged in this case. I'll now hear from the state on the issue of detention.
Thank you, Your Honor. It is the state's position that the PSA underestimates the clear danger that this defendant poses to these victims, risk of flight and obstruction if released. As Your Honor indicated and is marked as S2, he does score a 3 for failure to appear, a 4 for new criminal activity with a recommendation of release on level 2 pretrial monitoring. I would argue the danger that he poses to these victims are clear based on the current complaint warrant, which charges him with 2 counts of second-degree endangering the welfare of a child, based on an incident that occurred on January 7th of this year, where the 2 minor children reported to the Pleasantville Police Department that their parents had not fed them and there was no electricity, gas, or running water in the residence. I would rely on the facts previously discussed in the probable cause portion in regards to the danger that this defendant clearly poses to these victims. This defendant has a criminal history that spans back to 1994. This includes 11 prior indictable convictions, including a conviction for first-degree robbery, theft, burglary, forgery, theft by deception, shoplifting, and an aggravated assault conviction. The PSA also notes he has 2 prior DP convictions for shoplifting. In regards to the risk of flight and obstruction, the PSA does note that he does have 3 prior failures to appear, albeit they are older than 2 years. Additionally, the PSA notes that he has served several prior sentences to incarceration, and that in this case, if convicted, he is facing a presumption of imprisonment. So for those reasons, Judge, I would ask that you deviate from the recommendation of the PSA and hold this defendant pretrial. Thank you.
Now hear from the defense with regards to detention.
Thank you, Judge. Might sound like obviously the co-defendant of the previous case. I'll start with the PSA, Judge, because oftentimes it is a big determinant, but also I'll include what I've gathered from my client. He does agree this was a bad living situation that him and his wife, as he calls her, created via drug use, which he desperately asked me for help. The first thing he didn't ask me about today wasn't his freedom. It was about getting help and where are his children. As was stated to you, Judge, the children will not be near him. The PSA recommends bi-monthly reporting. The PSA has no new violent flag. That my client does go to court. The last time, the one violent offense he had, Judge, happened during the Bill Clinton administration in 1994. My client has not had a violent offense since then. His long history of the state points to one charge happened in 2012. All the other charges are at least 2 decades away, I'd say, or at least 18 to 25 years old. So I asked my client, how could this happen? Well, he was gainfully employed for 23 years at a Cape installation. He was injured at the job. He receives disability he receives workers' comp and disability via that injury. That injury caused the spiral along with his wife, and this led to the abhorrent conditions of the house. That said, he loves his children. The children are the ones who went to him. He doesn't want to pin it on his wife, but they went to him when they needed food. Him being injured, on disability, unemployed after 23 years of work, back on drugs after a 2-decade break from any type of criminal activity, point to someone who needs help and a middle ground we can meet at. Bi-monthly reporting even seems weak to me, but there certainly is the middle ground of ankle monitor, task evaluation, drug rehabilitation. These are the things he asks for. He has no record with the woman his co-defendant. He believed to get along with her. I don't know if that was used to her advantage or not, but he assures me that if anything, that she was not to point it, but she was the one bringing the drugs in, and the parent and the kids would go to him. He was just in a weakened state. So he would just kindly ask, if you take the PSA into consideration, you realize he's not a violent person since 1994. He's 52 now. He's a person with all those crimes mentioned are drug related. You can see it, shoplifting. It's always drug related. Then there's a huge gap where he's employed, and that points to relapse city. So if we could monitor him and get him the help, and then he can appear in front of you, Judge, if he's in front of you, we can get him to court, because his prior last two peers are decades old too, because all his criminal activities are decades old. So this is someone who was living in a horrible situation, one he attempted to fix and didn't do a good enough job in, and he's deeply remorseful for that. He wants to get back there, clean up the place, deal with life. He'll obviously not be near the children, so he will pose no risk to them, and he has never posed a risk to his wife. So I believe strongly in the PSA that so often is used against defendants. But I would even say if we have to meet in the middle ground, my client would be okay with that due to the circumstances of the house and him wanting to get it all cleaned up. I defer
Anything else from
support.
anything else from the state?
Nothing from the state, Judge. Thank you.
This is the court's ruling regarding prosecutor's motion for pretrial detention regarding State versus David Doyon. Again, complaint warrant W-2025-121-0102. Court has heard the representations of both defense counsel and the prosecutor, as well as having reviewed all the exhibits that were submitted. Based upon a review of all of those materials, the court finds that the defendant is 52 years old. He has 2 children with a partner who is a defendant in a related matter. In reviewing the PSA determinations, the court finds that the defendant is currently not on any pretrial monitoring, probation, or parole of any kind. He has a PSA score of 3 for failure to appear and 4 for new criminal activity. Those scores fall within the middle of the range. The PSA recommends release with conditions by monthly reporting. That's twice per month. The court has, again, in reviewing all that information, under the format or the prongs of the triad, which are failure to appear, safety of the victims in particular, and the community at large, as well as the risk that the defendant will obstruct the criminal justice process. The court first looks to the criminal record of the defendant. Again, he does not have any current pending. He did not have any current pending charges at the time of these alleged offenses. In addition, the defendant does have 2 prior disorderly persons convictions that relate to shoplifting. Both of them relate to shoplifting. The defendant has 11 prior indictable convictions, which include charges of aggravated assault, shoplifting, theft by deception, burglary, robbery, and forgery. I'll note that none of these prior convictions relate to domestic violence involving children or abuse or neglect of children. These offenses have varying dates, the earliest stemming back from 1994, as defense counsel indicated. The newest charge has a disposition date in 2012, having occurred in 2020. Court finds that to be quite remote in time. Defendant also has 2 prior violent convictions amongst that group, which are a 3rd-degree aggravated assault, a 1st-degree robbery involving a risk of bodily injury. And the court does note that that count was a very severe charge, being a 1st-degree offense. However, it has to be noted that the defendant does not have any failures to appear in the last 2 years. The 3 failures to appear predate the 2-year mark, and as I indicated a moment ago, I do find that those prior failures to appear are very remote in time, the last occurrences being from 1993 to 2009. I'll note that the defendant is older and more mature now. Additionally, as I indicated, he doesn't have any active warrants or detainers in New Jersey or any other state. The court, in reviewing all of the materials and representations made by counsel, gives due consideration to the recommendations contained in the PSA. And again, regarding the triad that I mentioned before, the court finds first, with regards to failure to appear, the defendant poses a moderate risk of failing to appear to future court appearances. I do note he's failed in the past, although those failures are relatively dated. And again, the court finds that there has been a number of years and increasing maturity or chance for the defendant to mature during that period of time. I do understand that the charges, the instant charges, are of 2nd-degree nature. They're severe, and there is a presumption of imprisonment there, which the court takes into account. However, the court finds and notes that although there exists a moderate risk of failing to appear, the court doesn't find it to be a high risk of defendant failing to appear. Secondly, the court finds the defendant, with regards to safety to the community at large, I do not find him at this point, given the most recent charges are shoplifting and endangering very specific children, allegedly his own children. I do not find him to be a significant risk to the community at large. Additionally, I do find, however, that the defendant does pose a significant risk to the victims in this matter, his own 2 children, and that defendant allegedly contributed to the creation of an unhealthy and unstable environment, an unhygienic and an environment that created significant living conditions, including malnutrition and habitation concerns in the home. However, I do also find that both children are in the custody of Division of Child Protection and Permanency, and that their involvement will follow a separate path, possibly through family court and the children in court case. For that reason, I do find that there is a safety to those children. However, the court does find that there are conditions that can be put into place to reduce the risk to those children. Finally, on obstruction of justice, the court finds that there is, again, a moderate risk for obstruction based upon defendant's lengthy criminal history, but also finds, as I did a moment ago, that there are non-monetary conditions of pretrial monitoring that can reasonably assure that this obstruction does not occur. Although the defendant's alleged conduct is severe and very concerning, the court does find that the conduct stems from a substance abuse concerns and poverty that follow from extensive substance abuse. And I do understand that the allegations of the defense that he may have fallen into this after a disability related to work involving a workers' compensation claim. The court is familiar with those sort of circumstances and finds that, given the totality of the circumstances in this case, that the defendant can be released with no contact provisions, no unlawful contact provisions put into place to ensure the defendant does not have unlawful contact with the alleged victims in this matter, his children, and strict substance abuse evaluation and treatment conditions put into place to put the defendant on a path to being drug and substance free. However, in formulating the release, the court does find that due to the severity of the underlying charges, including the defendant's criminal history, the recommendation of the PSA, and the underlying facts in this case, the court finds the state has not met its burden for pretrial detention. However, the court does find that although the state did not meet its burden in showing that no amount of monetary bail, non-monetary bail conditions of pretrial release, or a combination of monetary bail conditions would reasonably assure that the defendant will appear in court as required, assure the safety of the victims and the community at large, or that the defendant will not obstruct the criminal justice process. And although I'm denying detention at this time and I'm releasing the defendant, given the totality of the circumstances and given the court's review of the PSA recommendation, I will deviate from the recommendation of the PSA. I do not find it to be sufficient under the circumstances. I'll release him under level 3 monitoring, and I'll discuss those specific conditions in a moment. Court will release the defendant, Mr. Duyon, subject to the following non-monetary conditions. Sir, you must appear for all scheduled court proceedings. You must immediately notify pretrial services of any change in your address, telephone number, or other contact information. You are not to commit any offense during the period of release. You shall avoid all unlawful contact with the alleged victims of these crimes. Additionally, sir, you shall avoid all contact with the following witness that may testify concerning these offenses, and that is your partner, Beverly Owens. Avoid all contact with Beverly Owens. You shall also report to pretrial services telephonically once every other week, and in person every other week. That's a level 3 monitoring. In other words, on your typical 4-week month. Let's say the first week it will be telephonic, the week after that it will be in person, the week after that it will be telephonic, the week after that in person. You understand it will cycle that way. Sir, you will also refrain from possessing any firearms, destructive devices, or other dangerous weapons. You will refrain from excessive use of alcohol or any narcotic drugs or other controlled dangerous substances without a prescription from a licensed medical practitioner or as part of a licensed treatment program. Sir, you'll maintain and actively seek lawful employment if you're able to do so. You shall undergo available medical, psychological, or psychiatric treatment, including treatment for drug or alcohol dependency, and remain in a specified institution if you're required to do so based upon the recommendations of that evaluation. So specifically, I'm going to order you to undergo a substance abuse evaluation immediately upon your release at JBRC, that's John Brooks Recovery Center or equivalent. and you are to comply with the recommendations that they prescribe for your substance abuse, for any identifiable substance abuse condition. Additionally, sir, you are also to comply with any and all conditions of the Division of Child Protection and Permanency, and this may include participation in a domestic violence program, such as Fathers Ending Abuse or equivalent. The reasons the court finds for departure from the recommendations of pretrial services is due to chronic drug use, allegations of current or prior domestic violence, specific threats of future harm to the victims in this case, or witnesses in this case, specifically the co-defendant partner, and other relevant evidence presented to the court today. Sir, you must notify the court immediately in writing if you're detained in jail again or imprisoned, or otherwise you cannot appear at a court proceeding. If you fail to appear at a court proceeding or are arrested in another state or jurisdiction, you agree to waive all rights to extradition proceedings under New Jersey statutes and the demanding state or jurisdiction statutes with regards to extradition law. If you fail to appear, sir, a violation of any of the conditions of release, including that substance abuse evaluation and treatment that you must engage in, sir, or you obtain a restraining order, or you commit a new crime, it may result in the following penalties and consequences. It could result in an issuance of a warrant for your arrest, increasingly restrictive conditions, a revocation of your release, forfeiture of any monetary bail, or possible detention once again. Sir, I see that you are scheduled to return to court, and I'm going to order that you return to court on February 26th, 2025 at 9 a.m. That'll be before me, Judge Coombs, in courtroom number 7 here at the Superior Court, the criminal part in Mays Landing, New Jersey. Anything else from the parties at this time?
Judge, I would just ask that he also follow any recommendations of DCP&P, as well as submit to random drug testing during his pretrial service check-ins.
Defense, any objection?
No, Judge, we just hope he gets the treatment so he doesn't fail the test just right when he comes out, but I'm sure they're prepared for that type of thing.
Excuse me, Judge.
Yes.
I was looking at the complaints. Both of the defendants live at the same address. Is one of them going to have to go to a new address because they can't have contact with each other?
Yes. I ordered the Miss Owens to go to the domestic violence shelter.
Oh, I apologize, Judge. Thank you.
And there's to be no contact between them. And sir, I will also order that you comply with all random urine drug screens. Anything else from the parties?
Nothing from the state.
Nothing from the defense. Thank you, Judge. I'll see you at that court date with my client. And Mr. Duran, you must come to that court date.
All right, sir. We've set out a path for you to take care of these circumstances, sir. I wish you luck. Take care, sir.
You can leave the booth.
Thank you, Judge. May I be dismissed?
Certainly. Have a nice weekend, Mr. Imperial. Take care.
You too, Judge Coombs.
Mr. Joyne, you can leave the booth. Judge, I think he's talking. Did you want me to unmute the booth?
His attorney has already left.
Yeah.
So, Mr. Duyan, you can leave the booth, sir. Any additional issues you can address at your next hearing. Okay, sir?
Sir, please leave the booth. Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in first. People are going to learn how to act in a courtroom.
Can you hear it?
Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
I have no patience for that. And trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.